Hello, hello. Welcome to Crime in Court. My name is Heather, and as you can see from the thumbnail, we are going to read through the defense's second motion to dismiss charges. So, we just recently read through on my channel a motion to dismiss or to disqualify Judge Gull. That was a two-parter. Tonight, we're going to try to make this a one-parter. It's a little bit longer, so hopefully all is good. So let's get started. So again, this is a little bit different. This is to dismiss the charges altogether because of evidence that may have been destroyed purposely or negligently or both. So we're going to read through. We've already read through the or the first motion to dismiss the charges, but this is now the defendant has more ammo to write these motions. So let's begin. Let me shrink myself here. Please hit the like button and let's get started. All right, make myself a little bit bigger. That's good. All right, so the defendant's second motion to dismiss based upon newly discovered, destroyed, and or missing exculpatory or potentially useful evidence. Comes now the accused, Richard Allen, by and through counsel Andrew Baldwin, and pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution, Article 1, Section 12 of the Indiana Constitution and Indiana Code 353414A11, moves this court to dismiss charges against the accused for destroying or losing exculpatory evidence or potentially useful evidence in violation of the standards it's a long sentence, set out in Brady versus Maryland. In support of said motion, the accused states the following. So Brady is a case that took place in Maryland, obviously, and it's referenced to in many I don't know if you guys noticed it, but my light or my screen keeps flickering on my new computer. It's like it doesn't want to connect or something. I don't know. Anyways, sorry about that. So Brady versus Maryland is a case that is cited throughout the United States because it has to do with having exculpatory evidence and still moving forward with a trial. So actually, do I have my phone nearby? I don't know what I did with it. Oh, here it is. I usually do. Brady case law. Okay, so Brady case summary. The Supreme Court held that withholding exculpatory evidence violates due process where the evidence is material either to guilt or to punishment. So if the state is holding on to exculpatory evidence regarding Richard Allen, so if they have some other evidence that's pointing to some third party culprits, then that is Brady evidence because they didn't turn it over. So that, or if they didn't turn over that evidence, they're hiding that evidence, withholding that evidence, destroying that evidence, whatever it may be, that is part of Brady and how the courts proceed on that. So, in support of said motion, the accused states the following. Number one, that on February 7th, 2024, the accused filed his motion to dismiss for destroying exculpatory evidence and memorandum in support of said motion. Number two, in his first motion, the defense detailed how a February 17th, 2017 interview of third-party suspect Brad Holder was destroyed while in the possession of law enforcement along with multiple days of other interviews. So lots of interviews have been destroyed. And whatever was said in those interviews, we will never know because law enforcement tried to cover it up, or at least it seems that way. They were at least negligent in their handling of the recordings of these interviews. And there were no notes taken, according to them. So we will never know. Number 3, on March 18th, 2024, a hearing was held on said matter. 4, at the March 18th, 2024 hearing, Steve Mullen, investigator for the prosecutor's office, testified that other evidence was destroyed in 2017, as well as it was purportedly unintentionally taped over. So, if you haven't read through the May 18th hearing, we have the transcript. We've read through the transcript here on this channel. The links are in the description below. So Steve Mullen, an investigator in this case, testified that there was evidence that was destroyed or taped over unintentionally, supposedly. All right. You need to stop flickering. You set, like, no one's touching you. You need to just stop flickering, screen. It's not cool. Thank you. All right, so 5. Furthermore, at said March 18th, 2024 hearing, the defense tendered Mullins undated reports that purportedly explained how the evidence was destroyed. So the defense have reports on how it was destroyed, and they tried to bring that into evidence. All right, so number 6, the prosecution did not tender these reports to the defense until after the motion to dismiss was filed. Also, said reports were only turned over to the defense after the defense requested those items from the prosecution. And that's not how it should be. The prosecution should be turning over any kind of exculpatory evidence, and they know that. They know that, but it hurts their case. So they like to bury it, hide it, or at least this prosecution team does. Number 7, on April, is it a team or is it just Nick McClelland? I've only ever seen Nick McClelland, but obviously there has to be more people in the DA's office than just Nick, right? I don't know. I'm assuming. I shouldn't assume. All right, so number 7, on April 2nd, 2024, this court issued its ruling denying the defense motion to dismiss charges. 8, since the time of this court's denial of said motion, the defense has learned of other exculpatory evidence and or potentially useful evidence that the prosecution has not turned over to the defense, is missing, or the state of Indiana has destroyed. I mean, that's a big deal. And I can't stress how big of a deal that is. That there is evidence that could exculpate Richard Allen. I was going to say Stephen Avery. That's another case I'm working on. Any evidence to exculpate Richard Allen, anything that might inculpate others, all of that needs to be turned over to the defense in their discovery. And if you find out it's been destroyed or purposely withheld, that's a big deal. Big deal. Because you can't defend your client that way. You could have potentially the one piece of exculpatory evidence that sets this man free, and you're not turning it over. That's a problem. All right, number 9, just like Allen's first motion to dismiss, the missing destroyed evidence relates to third-party suspect Brad Holder. Oh, well, what a surprise. Brad Holder's missing phone extraction data. During a recent deposition of Brad Holder, the defense learned that Brad Holder is pretty sure that he turned over his phone to law enforcement on February 17th. He's pretty sure. 2017. 11. The prosecution has not turned over any data, extractions, reports, or other evidence from Brad Holder's phone. When did they give him a depo? So a recent deposition of Brad Holder. Sorry, that took me a minute to register the one that we were just on. So they did a deposition of Brad Holder. I wonder what came out of that. Very, very, very interesting. And so he says that he thinks he's pretty sure he turned it over, his phone, turned it over to law enforcement. And at this point in time, prosecution has not turned over any data extraction reports or other evidence of Brad's phone. Interesting. Number 12. Curiously, on the same day and at the same time that Brad Holder believes that he turned his phone over to law enforcement officers, his son Logan Holder also turned over his phone. 13. The prosecution has turned over the data extracted from Logan Holder's phone, but not any data extracted from Brad Holder's phone. Why not? Number 14. While the data from Logan Holder's phone was extracted, law enforcement apparently claimed that they failed to extract data from Brad Holder's phone, even though both he and his son turned over their phones to law enforcement at the same time. So you extracted the son's phone, but not Brad Holder's phone. That makes no sense. And I don't believe it. Number 15, because they were treated as suspects in the beginning. Supposedly, they were, like right at the beginning, Brad Holder, the Messer, and Elvis Fields, and all those interesting individuals that are in the Franks memorandum, they were suspects in the beginning. And suddenly, all of their interviews and evidence about them just disappeared or wasn't turned over. I have questions about that. A lot of questions. Number 15, Jerry Holman stated under oath at a recent deposition that he believes police just looked through Brad Holder's phone, but encouraged the defense to find out for sure from the FBI. And that is in a deposition taken earlier this month of Holman. So the defense is busy. They are busy taking depositions of key witnesses in this case, and I'm here for it and for all these filings because I think it's great that what a fantastic job these lawyers are doing, just FYI. Just amazing. They're public defenders, and a lot of times public defenders don't get the cred that they are due. Defense attorneys definitely don't get the cred that they are due. And these guys are doing it. They're they're doing things with coming out of their own pocket, money coming out of their own pocket because Judge Gull won't give them fees or won't compensate them for their fees or pay them in a timely manner. There's been a lot of issues with even just payment for them. So, like just their regular hourly rates. So it's been kind of a struggle. So hopefully that is not the case anymore. But yeah, so it's interesting that the defense has been um, giving depositions or conducting depositions. I don't know what the right term is for these key folks in their case that they need information on in order to get their client off or impeach them on the stand, all sorts of things that they are working on right now, I'm sure. So I give them lots of cred for all that they do. All right, number 16. When asked if he, Holman, would have extracted data from Brad Holder's phone if given the opportunity, Holman was non-committal. Quote, depends on the circumstances, but I think you'd have to ask the FBI what they did. End quote. Really, Holman? Weren't you one of the lead people in this case? Who was the lead person? I don't remember now who the lead investigator was. It might have been Holman. 17. Finally, after being pushed by the defense, Holman finally conceded that he would have extracted data from Holder's phone if given the opportunity. So, then where is it? 18. The defense finds it highly unlikely that law enforcement would take the time to collect both Brad Holder's phone and Logan Holder's phone, but then choose to only conduct an extraction of Logan Holder's phone, especially when Brad Holder was a suspect at that time and no evidence provided to the defense suggests that law enforcement considered Logan Holder a suspect. 19. On February 17th, 2017, documents specifically sought by the defense, Doug Carter's emails with the FBI provided evidence that A. Brad Holder was a suspect within days of the homicides and certainly on February 17th, 2017, when Holder interviewed at the Delphi police station and turned over his phone to law enforcement, meaning they should have done a phone extraction if he was a suspect. B. State Police Superintendent Doug Carter was aware that Brad Holder was a suspect. C. Even the top FBI agents in Indianapolis, Jay Abbott, was aware that Brad Holder was a suspect on February 17, 2017. D. Logan Holder was not mentioned as a suspect in these emails. So again, why would they do Logan's and not Brad's? So 20, this begs the question, why would law enforcement take both Brad Holder's phone and Logan Holder's phone, but only extract data from Logan Holder's phone when he was not himself a suspect? Exactly, but Brad was. So make that make sense, Delphi. But they would not extract any data from Brad Holder's phone when he was a suspect? Question mark? 21. Additionally, the defense possesses 101 phone extractions that law enforcement conducted on a variety of other phones, many of which seemingly have little or nothing to do with the homicides. 22. This begs another question. Why would law enforcement take the time to extract data from 101 phones, most of which were not owned by suspects, yet would not extract data from Brad Holder's phone when they had his phone in their hands on February 17th? And he was a suspect at that very time. Why, Delphi? Why? 23. The defense believes that the above information provides strong circumstantial evidence that law enforcement did extract the data from Brad Holder's phone on February 17th and has not turned it over to the defense, meaning they've had it for all these years and they're not turning it over. Logic and common sense support this belief. I agree. 25. If law enforcement failed to extract suspect Brad Holder's phone data while it was in their hands on February 17th, then the only other explanation would be that law enforcement was completely and utterly inept. That right there is a nice sentence. If they failed to do it unintentionally, then they're inept. Pretty much. Pretty much. If they did it intentionally or they're not turning it over intentionally, either the law enforcement or Nick McLeland are quite corrupt, trying to hold it or keep it from the defense. All right, so all evidence of Brad Holder's second interview with law enforcement is missing. 26. Additionally, Brad Holder testified that in his deposition that, in addition to law enforcement's February 17th, 2017 interview, which was purportedly accidentally taped over, the law enforcement conducted a second interview of Brad Holder sometime later, probably within a year or two of his first interview. Well, that's interesting. So the first interview taped over accidentally, let's just give them the benefit of the doubt that it was taped over accidentally for days. All of the Delphi homicide interviews were taped over, but sure, okay, accidentally. And then they go back to Brad Holder and interview him again a year or two later, and that one's missing too? Like, what? Come on now, guys. It's only a miracle that these defense attorneys found, like, they whittled away all of this information through the discovery that they've received because they've just received mountains and mountains of discovery. They're still receiving it up until this day. And they were supposed to have gone to trial on the 13th of this month. So there's that. All right, so number 27. Holder further testified at his deposition that A, law enforcement conducted this second interview at the Logansport police station. B, the interview took about an hour and a half. C, the interview was likely videotaped in an interview room. D, the interview involved much questioning about Patrick Westfall. Another one that's mentioned in the Franks memorandum. 28. After the deposition, the defense alerted the prosecutor's office that the defense had A, no phone dump extraction evidence from Brad Holder's phone, and B, no evidence whatsoever in the form of video, audio, reports, notes, or any other type of evidence of law enforcement's second interview of Brad Holder that took place at the Logansport police station. No phone dump, no evidence, nothing. It's like Brad Holder never existed in law enforcement's eyes, and all their questioning of him just evaporated. How does that happen? How does that happen unless, I don't know how that happens. The only way it happens, I see, is corruption. People at the top that have power that can whittle away people's rights and take away their freedom very easily. That is what law enforcement is. Law enforcement, we trust them to not be arresting people who are innocent and to not abuse their powers. And they have the power to take your freedom away at any moment for very, very weak probable cause, apparently, as is the case with potentially Brian Kohlberger, Richard Allen, many others. I mean, it's not the first time, and it won't be the last time that we have a wrongfully convicted individual, and it's very unfortunate. And he's not even convicted yet, but he's been locked away in solitary confinement for over a year, 2 years now. Wait, when did he get? He got arrested in 2000, like the fall, October or something, 2022. So yeah, a little over a year and a half. So or so. He's been in solitary confinement. Can you even imagine that? I can't. I've read on Turtle Boy's blog, I read through when he was arrested for basically the Commonwealth just wanted to silence him so that he couldn't out their characters in the case and talk about their bad behaviors. So Turtle Boy, right, Aiden Carney in the Karen Reid case, he was locked up in jail for 60 days, and it was he was definitely railroaded into getting locked up. And when he was there, he was in medical, so they kept him separate in like solitary. And he talked about the struggle so much. Like the one thing that he missed was just human interaction, being in a cell all day. Like he got out and he would interact with the guards a little bit in his like rec time, which he would only get like an hour or two a day, and then he'd have to go back to his cell. And then the next person he would see after like the morning, late morning, once he was back in his cell, the next person he would see would be like anyone bringing him food, his meals, and that was it. So not complained, but he wrote about the struggles of being in solitary for 60 days. So imagine Richard Allen, who's been there for a year and a half now, which is unbelievable. I mean, there's so many studies on why solitary confinement is so wrong, and it does so many things to the inmates psychologically that probably you can never overcome some of those anxieties and issues of being locked up in a solitary confinement. I can't even, hope I never have to. All right, so 29, on May 13th, 2024, the prosecution advised the defense by email that they cannot locate an interview of Brad Holder at the Logansport PD and have no record of Brad Holder's phone being downloaded. As of May 13th, the prosecution told the defense they cannot locate any interviews with Brad Holder and have no record of his phone being downloaded this month. I think someone's lying. 30. At a recent deposition, when Unified Command's Jerry Holman was asked about how the defense could obtain any information about this second interview, Holman said he had no idea but encouraged the defense to reach out to the Logansport PD to find out. And that's from his deposition. 31. The defense is not required to locate exculpatory evidence or potentially useful evidence of third-party suspects. That is a requirement of law enforcement. Exactly. And law enforcement needs to turn it over to the prosecutor. The prosecutor then needs to turn it over to the defense, which is such a dumb rule. Like, why shouldn't law enforcement turn it over to both so that both teams have it? It should be a requirement that they have to turn it over to both, or maybe like they upload it to a thing, electronically, and then it becomes, maybe law enforcement is like tapped into their system. I don't know if anybody has a program that can create that law enforcement uploads the data and then it gets distributed to lawyers on both sides. That would be like, technology, guys. Let's use it to our advantage. Anyways, 32. Also, make things simpler. At said May 2nd, 2024 deposition, Brad Holder told a third different story concerning how many times he met victim Abigail Williams, 2 times, and that one of Brad Holder's meetings with Abigail Williams took place at Patrick Westfall's house. Wait, what? He met Abby at Patrick Westfall's house? Holder did? At one of those times? I'm confused. I mean, I understand what it's saying, but why would she be at Westfall's house? What's the connection there? That's what I'm confused about. All right, 33. When Jerry Holman was confronted with Brad Holder's ever-changing stories concerning how many times Brad Holder met Abigail Williams, Holman stated, "Perfectly reasonable, in my opinion, that he remembered somebody insignificant. If you've only met them twice, you may not remember that, so I don't see exactly what you're asking me." So he's just he's basically shooing that little piece of evidence away that Holman or that Brad Holder is changing his story. He's just saying that's fine because that person must have been insignificant to Holder, so why would he remember all of the chance meetings that he had with her? Which I get, but I don't, because he's been questioned multiple times now over the homicides of Libby and Abby. So you would think he would know how many times he met her at this point. Anyways. All right, 34. When Holman was asked if it were likely that Brad Holder would not remember meeting Abby when Holder was asked 3 days after the homicides at his February 17th interview in 2017, but then 7 years later, he would remember meeting Abby twice. So Brad Holder in 2017 interview would not remember meeting Abby. Holman said that he would not remember meeting Abby, but then in 7 years later now, we're being told that he remembers meeting her twice. And Holman was asked about this, and Holman responded, yeah, possibly, I guess. that could be possible. All right, number 35. That's my dog. He like hops up and then he gets off of his bed and then lays on the cold floor and then he moans. All right, 35. Holman showed no curiosity nor interest whatsoever about why Holder's stories have changed. This attitude supports an argument which defense will later make in his motion, excuse me, that law enforcement have acted intentionally or in bad faith to conceal evidence to such a degree that they cannot even admit obvious factual inconsistencies that point the finger at third parties. So let's read that again. Holman showed no curiosity nor interest whatsoever about Holder's stories changing. Okay. This attitude supports an argument which defense will later make in this motion that law enforcement have acted intentionally or in bad faith to conceal evidence to such a degree that they cannot even admit obvious factual inconsistencies that point the finger at third party suspects. So, law enforcement has such a role in covering for these individuals that they won't even admit any kind of inconsistency at any point now because they're dug in so far. 36. Patrick Westphal was interviewed on August 17th, 2024. It's probably not 2024, probably 2023. And law enforcement extracted data from Westphal's phone. Then maybe that was 2017. Obviously, this is a typo. I'm not sure. Phone extraction, it was 2023. All right, so the phone extraction shows that Westphal's phone had no data prior to August 11th, 2023, which was the day that law enforcement contacted Westphal and asked him to come in to be interviewed 1 week later. So he went and got himself a new phone on the day that law enforcement contacts him about coming in for an interview. That's not suspicious at all. In other words, it appears that Patrick Westphal either erased all of the phone data on his phone or purchased a new phone after police contacted him on or about August 11th, 2023. The only data found on Westphal's phone was between August 11th, 2023, on or about when police contacted him, and August 17th, 2023, when he was interviewed. No texts, videos, photographs, email messages, nor any other data existed on Westphal's phone before the day that police contacted Westphal on August 11th, 2023. That's a big deal. Number 39, when Jerry Holman was confronted with the fact that Patrick Holder likely erased or attempted to hide his phone data from the state police, Holman claimed that he found nothing unusual, stating, "People erase things all the time." No, people don't just reset their phones all the time. People don't do that. People like to keep their phones in the way that they have it because they work so hard to get their apps where they want it, and yeah, people don't want to mess with that. All right, so later, Holman stated that he found nothing suspicious about Patrick Westphal deleting or concealing his phone data before his interview on the 17th. Number 40. Again, Holman's attitude towards third-party suspect Patrick Westphal supports the defense's position that law enforcement has intentionally destroyed evidence or acted in bad faith or have intentionally not provided missing evidence such as Brad Holder's second interview as well as other items identified in this motion. Number 41. At his August 30th, 2023 interview, State Trooper David Vito did not even ask Brad Holder if he would allow state police to extract data from Holder's phone, even though it is clear that Holder had brought his phone with him to the interview. So why wouldn't you extract his phone? 42. Therefore, it is not known whether Holder similarly hid erased data from his phone like it appears Westphal hid and erased data from his phone. But we could probably assume that he might have. So this trooper did not even ask Brad Holder if he would allow state police to extract his phone. Unbelievable. Like, are you investigating a homicide or are you just playing around? And being an investigator is just your day job, and you go, or it's just a hobby, I should say, and you go around interviewing people, but not taking their phones, in suspects, mind you, and not extracting their phones or anything like that. I don't think so. All right, number 43. It certainly is curious as to why Vito did not request Holder's phone data when Holder brought his phone to the August 30th, 2023 interview. 44. It is also curious as to why Vito failed to ask Brad Holder one single question about Elvis Fields. This was when? August 30th, 2023, which was after, no, just before the Franks memorandum came out. All right, 4. It is also curious as to why Vito failed to ask Brad Holder one single question as to the incriminating statements that Amber Holder attributed to Brad Holder that are detailed in Frank's 1. Vito's failure to ask such important questions to Brad Holder during the August 30th, 2023 interview supports the defense contention that law enforcement is acting in bad faith because they're not even doing their due diligence to interview these individuals or get the evidence against them. Mimicked crime scene image found on Brad Holder's social media is lost. 47. In addition to Holder's 2017 missing phone extraction and missing evidence of Holder's second interview at the Logansport police station, what are the chances that you lose 2 interviews of the same person from different police stations, mind you? As well as Holder's taped over first interview from February 17th, another key piece of evidence is also missing: the mimicked crime scene photo that was on Brad Holder's social media pages. 48. Trooper Purdy viewed this mimicked crime scene image on Brad Holder's social media page sometime in the spring of 2017. This image was marked as Exhibit F in Purdy's depot and discussed on those pages. All right, so 49. This mimicked crime scene image found on Holder's social media page holds an eerie similarity to the actual crime scene. 50. In the mimicked crime scene image found on Holder's social media page, the bodies of 2 women appear to be staged, laying on the ground in the woods with branches laid across their bodies. 51. One of the women in the mimicked crime scene image found on Brad Holder's social media page has her arms staged, positioned in a similar manner as one of the victim's hands were staged and positioned in this case. 52. At the time that Trooper Purdy observed the mimicked crime scene photo on Brad Holder's social media page, the general public did not have knowledge of the appearance of the crime scene, the positioning of the bodies on the ground in the woods, or that branches and sticks were arranged on the bodies. So Brad Holder's social media image that he posted, which is now missing, it was very similar as to the crime scene laid out, and things about it had not been made public yet. So what does that tell you about Brad Holder? There's a connection there. All right, it's number 53. In an April 12th, allegedly, I'm just saying, there is a connection. In an April 12th, 2017 report from Trooper Ryan Winters, it was learned that the state police also came into possession of said mimicked crime scene image through an internet sleuth named Ryan Boucher. I don't know. He alerted Winters to the disconcerting images on Brad Holder's social media pages and then sent those said images to Trooper Winters over the internet. 55. On April 12th, 2017, Trooper Winters then shared with Jerry Holman his knowledge of the mimicked crime scene images found on Holder's social media pages and the other information. 56. Because of the similarities between the images that Boucher sent Trooper Winters from Brad Holder's social media and the crime scene, Trooper Winters requested that Brad Holder be re-interviewed. So Trooper Winters saw these images on Brad Holder's social media and wanted Brad Holder interviewed again. 57. Despite that request, state police ignored Trooper Winters and never re-interviewed Brad Holder. Acting in bad faith? Yes, that sounds like. Brad Holder was only interviewed in August 2023 after Jerry Holman was challenged by the defense to reopen the Brad Holder investigation. Boom. Brad Holder was only interviewed in August 2023 after Jerry Holman was challenged by the defense to reopen the Brad Holder investigation. That's pretty crazy. And yet, we still don't have a phone extraction. So, all right, 58. To this day, the prosecution has failed to turn over the mimicked crime scene image that Purdy found on Holder's social media in 2017. 59. Fortunately, because internet sleuth Boucher had saved that image that he had turned over to Trooper Winters, the defense team was able to drive to Georgia and retrieve that image. Holy moly. These guys have been busy, really vigorously, zealously defending their client, and this is crazy. That in like one of the hardest cases, Delphi and Karen Reid, they are so similar. It's crazy. I mean, it's totally different circumstances, different crime. I mean, kind of, but still ended in life lost. And there's a lot of corruption going on under or behind the scenes in these cases. And it is apparent when you start looking at the court documents that there are some issues going on with these smaller towns here. All right, so they drove to Georgia to retrieve that image. Hold on one second. Sorry about that. I just had to make sure that the dog got her a little comfy spot. All right, so where was I? Defense drove to Georgia. 60. When deposed, Trooper Winters claimed that the state police could not access the images that Boucher found on Holder's social media that Boucher then turned over to the state police. Read that again. When deposed, Trooper Winters claimed the state police could not access the images that were found on Holder's social media. Interesting. All right, so number 61. How could state police lose such an important piece of evidence as an image found on a suspect's social media that mimics the crime scene? I mean, really, that's evidence right there, if there ever was any. 62. The defense again would proffer that the mimicked crime scene photo was not lost. Logic and common sense dictates that such an important piece of evidence would not be lost by state police. 63. The defense is filing simultaneously herein its memorandum in support of its second motion to dismiss based on newly discovered, destroyed, and/or missing exculpatory evidence, as detailed in said memorandum. If the defense can show that the missing evidence is exculpatory in nature, then the defense does not need to show that the missing evidence was intentionally destroyed. 65. If, on the other hand, the defense cannot show that the missing evidence was exculpatory in nature, but can show that the missing evidence is potentially useful evidence, then the motion to dismiss should still be granted if the defense can show that law enforcement intentionally or acted in bad faith regarding the destroyed or missing evidence. Interesting. So basically, you need to dismiss the charges if the defense can show that the missing evidence was exculpatory in nature. And you don't have to show whether it's intentional or not. Or you just have to show that it would be useful evidence to the defense. And then in either case, the motion should be dismissed. So she just has to they just have to prove that it's useful evidence. That's like the lower bar to meet. But if they meet the bar that it is exculpatory, then they don't need to show anything else. All right, so the exculpatory nature, blah, blah, blah. Try that word again. The exculpatory nature of the missing evidence. Number 66. Currently, the list of missing evidence that the prosecution has not turned over to the defense includes the following, and there's a lot here. Video of Brad Holder's first interview from February 17th, 2017. Video of Logan Holder's interview from same day. Data from Brad Holder's phone extraction from the same day. Video of Brad Holder's second interview with law enforcement taken at the Logansport police station sometime in 2017 or 2018. We don't even know the date. Oh my gosh. The audio taken from Brad Holder's second interview with law enforcement taken at the Logansport sometime. So both the audio and the video are gone or missing. Any reports, notes, or documents concerning or referring to Brad Holder's second interview at the Logansport police station. Mimicked crime scene photo observed by Trooper Purdy on Brad Holder's social media page, and images Ryan Boucher sent to Trooper Winters on April 12th, 2017. 67. Notice that all missing items are related to third-party suspect Brad Holder. Yes, I did notice that. I surely did. Number 68. Also, note that the prosecution is asking that the defense not be allowed to even mention the name Brad Holder during trial in their motion in limine. We read over that, how they didn't want any talk about like Brad Holder and talk about Odinism, anything about a third party culprit, any of it. They didn't want it, anything about ritualistic sacrifices and things like that. They did not want discussion of. And that still hasn't been ruled on, the motion in limine, but we know how Judge Gohl rules and how she probably would have ruled on that. If and how she probably would rule on it if given the chance. Hopefully she is not given the chance because there's the motion to dismiss, right, or to disqualify her right now, and that has to be ruled on by Judge Gohl before any other issues in the case can be ruled on. So it has to be, that takes priority. It needs to be dealt with first. So a hearing that they had for this week was actually today, the 21st, 22nd, and 23rd, that this hearing was supposed to take place to go over all of their motions that are still outstanding and any other issues, and scheduling, since she just went and scheduled the trial and didn't give the defense any time. So those things need to be hammered out. But before they can, she canceled those the hearings because she needs to rule on the disqualification motion first. All right, so number 69. Currently, the list of evidence that the prosecution failed to turn over to the defense until the defense requested the prosecution to turn it over, or upon the prosecution's realization that the defense would soon be learning about the existence of said evidence, includes. So did you catch that? Like, I read through that fast, but anything that these are things that the prosecution has failed to turn over, and they might have had to turn it over because the defense requested it, or the defense would soon be learning about it and would then be requesting it. So that's the only reason they receive these things. A Todd Click letter and accompanying 85-page report the prosecutor held onto this evidence for over 4 months until he knew the defense would learn of its existence. B. Multiple Elvis Fields interviews. C. Rod Abrams interviews, also mentioned in the Franks report. D. Multiple Johnny Messer interviews, also in the Franks report. Multiple Taylor Hornaday interviews. I believe they're in one of not the first Franks, but maybe the second or third one. I can't remember. And Ned Smith interview and Libby German phone dump. So they don't even have Libby's phone dump? Are you kidding me? Or they had to ask for it, one or the other. All right, so 70, notice that all items A through G are in paragraph 69 above are related to third-party suspects and Odinism. I did notice that. I did. 71. Also, note that the prosecution is asking that the defense not be allowed to even mention any of these third-party suspects or Odinism during trial. Right. They want to completely cut off the defense's ability to defend themselves. The defense put out their defense strategy long ago in the Franks memo back in August or September 2023. And they put basically their defense strategy forward. So the prosecution now knows where the defense is going to go. So they're more prepared now, and then they have other ways to twist and bend things to their advantage because now they have more time to think about it, which is also going on in the Karen Reid case. I'm telling you, these cases are so similar. Anyways, yeah, okay. 72. The evidence that the defense does have in its possession showcases that on multiple occasions, third-party suspect Brad Holder has changed his answer concerning a very basic question. How many times has he met Abigail Williams? 73. According to the only police report that memorialized Brad Holder's accidentally destroyed first interview, Holder stated that he had never met Abby Williams. 74. At the time that he had first approached, or at the time that he was first approached by law enforcement, which was February 17th, 2017, and asked that question, how many times did you meet Abby Williams? Common sense would dictate that the answer would be fresh in Brad Holder's mind and easy to detail because of A, the proximity in time that Brad Holder's son dated Abby Williams. Logan Holder was dating Abby Williams at the time of the homicides, and B, the enormity of the situation, i.e., two girls' lives had been taken, one of whom dated Brad Holder's son. There's a huge connection there, and why was that not looked into? 75. If Brad Holder is in any way involved in the homicides, as the defense believes, the evidence strongly supports, then Brad Holder's claim that close in time to the homicides that he never met Abigail Williams is understandable. Denying that he, Brad Holder, had ever met Abby Williams could, in Holder's mind at least, cause the police to take their action or attention off of him. So he may have lied back in his first interview, right? All right, number 76. If at his February 17th interview, Holder was telling the truth that he never met Abby Williams, then his answer to police, when asked the same question even 6.5 years later on August 30th, 2023, should easily be the same. I never met her. Because a father would definitely remember if he had ever met his son's girlfriend who had been unalived. Try not to say unalived because I don't love it, but don't want to be stricken from YouTube, so I have to play by their rules. I try to say homicide or other ways of phrasing it, but I just couldn't in that sentence, so I apologize. Conversely, a father would know if he had never met the girlfriend of his son involved in a high-profile homicide case. 77. However, if at his February 17th interview Holder was not telling the truth as to how many times he met Abby Williams, then it may be difficult for Holder to remember what lie he told law enforcement 6.5 years earlier when he was re-interviewed in 2023. At his August 30th, 2023 interview, Brad Holder's story changed. Now he claimed that he, in fact, had met Abby Williams one time. 79. Either Brad Holder intentionally lied to police in 2017, closer in time to when Logan dated Abby, or Brad Holder had simply forgotten his meeting with Abby Williams, but then somehow remembered that meeting 6.5 years later. 80. Then at this May 2nd, 2024 deposition, Brad Holder provided yet a third different answer. He actually had met Abby Williams 2 times. So it's changed 3 times now. He's given 3 different answers. 81. Furthermore, at his May 2nd, 2023 deposition, Holder remembered that one of those meetings occurred at Patrick Westfall's house, which again makes no sense because Patrick Westfall, wasn't he an adult? Why would the girls be there at the house? I wonder. Unless there was something that somehow these girls were involved with these men. And I say men because most of them were grown adult men, with the exception of Logan Holder. So maybe there was some association that they had with them that the family didn't know about. Like maybe they met him online or something and they lured him out there. That's one of the theories that I think holds some weight. But since we don't have Abby or Libby's phone dump, I guess we won't know until we get that. All right, so 82, Brad Holder's ever-changing answers to such a simple question provides evidence that the missing items A through H detailed in paragraph 66 are exculpatory in nature. Bam. 83, when combined with the evidence contained on Brad Holder's social media pages, including images of a rune inked onto Holder's hand that mimics the way sticks were found on Abby's body, as well as all the other evidence detailed in Frank's 1, the ever-changing stories of Brad Holder on the simple topic of how many times did you meet Abby Williams, should all provide insight into why the defense believes that the missing evidence contained obviously is exculpatory evidence. How could it not be? Number 84, it would be impossible for the defense to show that the missing evidence contains clearly exculpatory evidence. Therefore, the defense is left with providing circumstantial evidence along with logic, reason, and common sense as to why the many missing items would contain obvious exculpatory evidence. I mean, these are some sound arguments, and these have been well thought out, I think. I mean, they've been working on this and planning on their approach, I think, for a while here after getting back on the case from the Supreme Court. 85. The defense believes that it has shown that the missing destroyed evidence is exculpatory in nature. The missing/destroyed evidence is exculpatory, but even if the court disagrees, the court should find the missing destroyed evidence as potentially useful and dismiss the charges anyways. So 86, as detailed in the accompanying memorandum, which we'll read, if this court finds that the missing destroyed evidence is not exculpatory, but does find that it is potentially useful, then the court should dismiss charges. If it also finds that law enforcement intentionally caused the potentially useful evidence to be destroyed, or they acted in bad faith regarding the missing evidence. So there are multiple ways in which the court can find that the evidence was either potentially useful or completely exculpatory, and even that law enforcement might have been intentionally acting in bad faith, then she needs to dismiss the charges if she finds any of those to be found. But who's going to rule on this if Judge Gull is waiting on disqualification for herself? I mean, I guess it's for the record for the next judge to dismiss the charges, which makes sense. All right, so 87, Frank's 1 through 4 provides many reasons of why this court should believe that law enforcement intentionally caused the potentially useful evidence detailed herein to be destroyed or acted in bad faith. 88, the defense incorporates the contents of Frank's 1 through 4 in this motion. 89, provided below are a few facts that support the defense contention that law enforcement has acted in bad faith or intentionally lost or destroyed evidence, or even have failed to turn over said evidence to the defense. A. Missing portions of vital video from Jerry Holman's 10/26/22 interrogation of Richard Allen. Oh, so there's missing parts of Richard Allen's interview. What? Wow. Jerry Holman interrogated Richard Allen I'm speechless, on October 26, 2022, and said interrogation was videotaped. However, the first few minutes of the interrogation are inexplicably missing. The missing portions of the video, according to Jerry Holman, would have shown Holman discussing Richard Allen's Miranda rights and freedom to leave the room. Oh, buddy. Oh, no, 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 no. That is why you record that Miranda rights. You can't just say, oh, this missing footage, that's where I gave him the Miranda rights. No, you can't you can't do that. You need that on camera that they're waiving their rights. All right, both important concepts that might support the legality or illegality of Holman's interrogation. So the whole interrogation might be just illegal because there might have been no Miranda waiver. All right, so no explanation exists as to why the only portion of the videotaped interrogation that is missing is the crucial beginning of the interrogation. The missing video supports the defense contention that Holman knew he had screwed up and therefore edited out the first few minutes of the interrogation to avoid the statement being suppressed. What did Holman say in that part? Hmm. Oh, oh no, no, no. For his for for Richard Allen's statement being suppressed. That's what makes sense. So in order to suppress any like statements or confessions that Richard Allen may have said in that interview, they need to know whether or not that Miranda warning or Miranda was given or not in order to find out if it was legal or not and whether they can suppress the statement or not. All right, so next, the missing video from Holman's October 26 interrogation of Richard Allen is evidence of intentionality of law enforcement involving the concealment or destruction of evidence and or evidence of bad faith. B. Jerry Holman lied in his August 10th, 2023 deposition that Brad Holder was never a suspect. In his August 10th, 2023 deposition, when asked if Brad Holder was ever a suspect, Holman said the following: "Not really, no." However, it is clear from reviewing emails between Doug Carter and the FBI that Brad Holder was a suspect very early on in the case. They could have solved this case potentially right away, but yet they sat for almost 7 years until they arrested someone who we have no idea how he's connected to the case. Makes no sense. All right, so as stated before, Holder was thought to be a suspect, and his name was known as a suspect even at the highest level of the state police, Superintendent Doug Carter, and even known to Indianapolis top FBI agent Jay Abbott. So you would think that Unified Command would have known this if Superintendent Doug Carter knew, because he's part of Unified Command. So you would believe, it would be um, easy to assume, I guess, that all of Unified Command knew that they were suspecting Brad Holder. So I think Unified Command is dirty. I really, really do. That's my opinion, and I'm allowed to have it. And my opinions are my own and no one else's, and whatever. It's just my opinion. Don't get mad. All right, so the fact that Holman misled the defense by claiming that Holder was not really a suspect is evidence of the intentionality of law enforcement involving the concealment of evidence and or evidence of bad faith. Prosecution failed to turn over the click exculpatory evidence for 4 months and then only turned it over after it was obvious that the defense would be learning of the existence of the click letter. As detailed in Frank's 1 and numerous other pleadings, the prosecution chose to not turn over exculpatory evidence from May 1st, 2023 until September 8th, 2023, of a letter from Todd Click and 85 pages detailing his investigation into the Odinist ties. Contained in the click letter was evidence that 3 law enforcement officers who investigated the case believed that third party suspects Brad Holder, Patrick Westfall, and Elvis Fields were involved in the homicides, and Click's belief that the evidence supporting their involvement in the homicides was much more compelling than the evidence against Richard Allen. As stated in the previous pleading, it is hard to believe that a much stronger example of exculpatory evidence could exist than documentation that 3 law enforcement officers essentially believe that the wrong man may have been arrested. I mean, you don't usually get that. Law enforcement never wants to, not never, but law enforcement usually does not want to admit when they're wrong, even when they might clearly have the wrong person sitting in jail. They like to double down sometimes because they don't want to admit that there are problems in the system. There are many. The fact that the prosecution refused to not immediately turn over the exculpatory click letter for over 4 months is evidence of the intentionality of law enforcement involving the concealment of evidence and or evidence of bad faith. And I think bad faith of the prosecutor as well. The prosecution failed to turn over exculpatory evidence contained in several videotaped statements until after the prosecution knew that the defense would soon learn of their existence. As detailed earlier in this motion and in Frank's 1, the prosecutor failed to turn over several videotaped interviews that provide exculpatory evidence concerning third-party suspects until after it was clear that the defense would soon be learning of the existence of those videotaped interviews. Wow. The prosecutor turned over those videotaped interviews nearly 9 months later than required under rule and statute. Wow. Those videotaped interviews provided exculpatory evidence in terms of blown alibis of third-party suspects, as well as connectivity between third-party suspects and also provable lies told by third-party suspects concerning their knowledge of other third-party suspects. I feel like I said that third-party suspects a lot, but I mean, that's crazy. So there's third-party suspects. So there's a connection between the third-party suspects and also proof of their lies, basically. All right, so the fact that the prosecution failed to turn over exculpatory evidence that supports the involvement of third-party suspects in committing the homicides until after the defense would soon learn of their existence is evidence of the intentionality of law enforcement and the prosecution involving the concealment of evidence and or evidence of bad faith. Prosecution and law enforcement attempted to conceal the identity of a Purdue professor whose testimony contradicted the sworn statement of Jerry Holman. This matter has been detailed in Frank's 1, 2, and 3 and in various other pleadings previously filed. At his August 10, 2023 deposition, Jerry Holman stated under oath that part of the reason that law enforcement ruled out that persons practicing Odinism or some type of cult had committed the homicides was because a Purdue professor had ruled out such a possibility. Wow. So Holman says this professor ruled out the possibility of Odinist practices. However, after reviewing the Purdue professor's report prepared on or about March 1st, 2017, as well as listening to the Purdue professor's September 19th, 2023 interview, it was determined that the Purdue professor never made such a claim as Jerry Holman stated in his deposition. Furthermore, at his deposition, the Purdue professor, named Jeffrey Turco, specifically denied that he had ever made the very statements that Holman attributed to Turco. At his deposition, the Purdue professor denied that he ever made those statements to Jerry Holman. Awesome. All right. I mean, this is great. I don't read books anymore. I used to read like homicide mysteries and whodunits and stuff like that. Kevin O'Brien, he is one of my favorite authors. He writes some really intense, chilling uh, books that keep you on the edge of your seat. And now my dog is on my equipment. Can you stop, please? I need you to move over. That's all. Just move over. Okay. Um, 1 second. Sorry about that. Dog problems. Um, I don't remember what I was saying. So moving on. All right. Oh, Turco, the professor, never. He denied in his deposition that he ever told Holman that there was no ties. Additionally, the prosecution told the defense in a September 6, 2023 email that the identity of the Purdue professor was still unknown and may not ever be able to be found. Now, that's just like wild to me that law enforcement is like, oh, we don't know. We don't have any record. We don't know who this person is. We can never find him. Sorry. Moving on. Just move on with your case, defense attorneys. Just move on. No. We're going to ask questions. Why? Why was this Purdue professor not turned over? All right, so this is untrue, as Jerry Holman had already learned of Jeffrey Turco's name weeks earlier. So he knew who the professor was when he intentionally claimed that he did not know. Additionally, the defense learned that the actual Purdue report from March 1st, 2017, which also contradicted Holman's deposition testimony, was in the possession of law enforcement since that time, but was purportedly rediscovered by law enforcement by uh, August 2023. The prosecution finally produced said report to the defense on October 4th, 2023, and only upon request of the defense. So what is this again? Sorry. There's so many so many points. I can't keep track of everything. The defense learned that the actual Purdue report was in the possession of law enforcement since that time, but it was purportedly rediscovered. They had it this whole time, but they just rediscovered that they had it. So they just magically found it. Jerry Holman's August 10th, 2023 deposition testimony was false concerning the findings of the Purdue professor, and therefore his testimony is evidence of law enforcement's intentionality in attempting to conceal evidence and/or evidence of bad faith. The attempt of law enforcement and the prosecutor to conceal the identity of the Purdue professor is further evidence of intentionality in attempting to conceal evidence and/or evidence of bad faith. The prosecution failed to turn over one of the key pieces of evidence for nearly 9 months, and then only after the defense kept requesting the prosecution for the same. A key piece of evidence in the case is the phone data extracted from victim Liberty German's phone. Prosecution and law enforcement had possessed that evidence for 5 years prior to Richard Allen's arrest and therefore would have been able to provide that evidence immediately to the defense. However, the defense did not receive that evidence until September 8th, 2023, almost 9 months later than required under criminal rule. After the defense had a chance to review said data from the phone, it was determined that exculpatory evidence existed in the phone that did not support law enforcement's timeline and supports that third-party suspects were involved in the homicides. So, not only did we find exculpatory evidence on the phone, but we're also finding that the homicides didn't take place around the same timeline that law enforcement's telling us, which we kind of knew because of the geofence data that was put or that it was explained in the Franks 4 memo about the fact that there were other phones in the area at that time that either there were 3 or 4 phones around that area around the time of when the homicides, according to law enforcement, were taking place, which was that afternoon. And we find that those 3 phones were either the perpetrators or they could have been eyewitnesses, or there was nothing happening at that time at all, and no one has come forward to be a witness because they didn't see anything. So all of those things basically state that it might not have been that time. And if those 3 phones that they got the geofence data from happen to have no connection and no ties, and they're cleared, or they're, um, not considered suspects, I guess, then what? Then the homicides definitely took place at a different time. All right, so after the defense had a chance to review that data, it was determined the exculpatory evidence existed in the phone that did not support law enforcement's timeline. The failure of law enforcement to turn over Liberty German's phone for nearly 9 months, thereby concealing exculpatory evidence the defense could have been exploring from the beginning of their representation, is further evidence of intentionality in attempting to conceal evidence and or evidence of bad faith. Law enforcement concealed the Blocher, I have no idea, report until April 26, 2024. On April 26, 2024, the state of Indiana turned over a report from Steve Mullen concerning the findings of Sergeant Mitch Blocher of the Indiana State Police. Contained in the body of that report was exculpatory information concerning ping information that supports that on February 13th, 2017, the victims were not located at the same scene as they were found on February 14th, meaning they weren't there. On the 13th, they weren't there. So they were moved, taken somewhere. We don't know for sure, but they were not just standing around in this like wooded area waiting. They weren't I don't know what I'm trying to say. Never mind. All right, so contained in the body of that report was exculpatory information concerning ping information that supports that February 13th the victims were not located at the same scene where they were found. So definitely, as I've stated, I believe that they were taken somewhere and then moved to that scene. And it wasn't even that the crime scene where they were found wasn't even where the homicides took place, as far as we know, because it it could have it could just be a staging area where the girls were found, and they were staged in that manner with the sticks to look like runes, and they were brought there after they were potentially already their lives had already been taken. Possibly. That's a theory I think is plausible. But what do you guys think about that? All right, let's keep going. This one's a long one, guys. Sorry. The failure of law enforcement in turning over this report for well over 1 year beyond when the prosecution was required to turn it over, and only after the defense sent a certified letter and filed a motion to compel and for sanctions demanding that the prosecutor turn over certain evidence, is further evidence of intentionality in attempting to conceal evidence and or evidence of bad faith on the part of the prosecution. They keep mentioning law enforcement is in acting in bad faith, but I really want to nail home that Nick McClellan is also acting in bad faith and probably should have sanctions and or misconduct looked at. Anyways, so Tobe Lesenby contracted the sworn testimony of both Jerry Holman and Tony Liggett concerning the number of people involved in the homicides. This matter is detailed in Franks 1. Both Liggett and Holman testified under oath that only one person, Richard Allen, was involved in the homicides. This proclamation under oath by Liggett and Holman would negate the defense's contention that evidence supports that multiple people involved in Odinism were involved in the homicides. However, when Tobe Lesenby was deposed, he stated under oath that Tony Liggett actually believed that multiple people were involved in the homicides. Thus, conflicting sworn testimony of law enforcement is further evidence of intentionality of the part law, of law enforcement to conceal their actual beliefs concerning the number of people involved in the homicides of the victims in order to direct the defense away from theories that Odinus were involved in the homicides, and additionally is evidence of bad faith. I kind of agree. No recordings of Richard Allen's interview with Dan Doolin exist. In 2017, Dan Doolin has stated that he knew that he was audio recorded, that he had audio recorded interviews when conducting interviews of tips and leads. Doolin claims that he now believes that he never audio recorded his interview of Richard Allen. I think I must not have audio recorded it because all of the other ones that I had are in a file on my computer, and I listened to each of them just in case they were mislabeled. Every audio recording I have, and none of them was Mr. Allen. This interview is crucial as what Doolin claims Allen told him. Doolin helped Oh wait, hold on. I read that wrong. This interview is crucial as what Doolin claims Allen told him helped establish the timeline used to secure a search warrant and to arrest Allen. So this interview with Doolin, this interview that we don't have audio or video of, is what we're using to establish probable cause, apparently, in the timeline. It gave them the ability to get a search warrant, apparently, and to arrest Allen. So I don't know what he said, but it would be crucial to find that interview and listen to it. The defense believes that Richard Allen was taped recorded and that the missing tape supports intentionality on the part of law enforcement and or evidence of bad faith. The missing mimicked crime scene image, this was detailed earlier in this motion and in Frank's 1. The fact that this incredibly exculpatory piece of evidence cannot be accessed and therefore is still missing, causing them to travel to Georgia to obtain said image, is evidence of intentionality on the part of law enforcement to conceal exculpatory evidence and or evidence of bad faith. I agree. Brad Holder is a key third-party suspect, yet Jerry Holman denied that fact, and then law enforcement failed to turn over multiple pieces of evidence that support Holder's involvement, along with other third-party suspects identified in Frank's 1. Furthermore, law enforcement have claimed that Brad Holder's initial interview was taped over. Furthermore, law enforcement claim apparently that they never extracted data from Brad Holder's phone when they extracted data from at least 101 other phones from people who weren't even suspects, like Holder was. Furthermore, law enforcement claim apparently that they never extracted data from Brad Holder's phone when they extracted data from Logan's phone, his son, which was turned over to the police at the exact time that Brad Holder turned over his phone. So again, why didn't they do both? Furthermore, law enforcement has turned over zero evidence of Brad Holder's second interview conducted at the Logansport police station, and the defense only learned of said interview through a deposition of Brad Holder conducted on May 2nd, 2024, so this year. Furthermore, law enforcement claim that they cannot access the mimicked crime scene photo that was on Brad Holder's social media page. All of the issues of missing evidence surround one person, Brad Holder, and Odinism, which the prosecution is also attempting to block the defense from even mentioning at trial, which is BS. You can't block them from defending their client. I hate that they're doing that to them. All right, so Richard Allen cannot have a fair trial when exculpatory evidence that would support the involvement of third-party suspects is missing. Only so many coincidences can explain away why so much evidence concerning Brad Holder and Odinism is still missing. I don't believe coincidences. I don't believe in any coincidences. I think What's supposed to happen is meant to happen. And if things are also, if you're finding things to be too coincidental, then there's a reason. Something is trying to tell you something. And I believe that's the case in this case. So only so many coincidences can explain away why so much evidence concerning Brad Holder and Odinism is still missing and why the prosecution failed to turn over so much of the evidence that the defense has or does in fact possess concerning third-party suspects for 9 months or more, and only after the prosecution knew that the defense would soon be learning of the existence of that third-party suspect evidence. The bad faith of law enforcement and prosecution has been proven through these numerous examples of missing evidence and evidence that the prosecution failed to turn over to the defense in a timely manner. Because the missing evidence is exculpatory in nature, charges against Richard Allen should be dismissed. Even if the court finds that the missing evidence is not exculpatory, it is clearly potentially useful evidence, and the numerous examples of bad faith contained in this motion require that charges against Richard Allen be dismissed. Beautifully worded, Andrew Baldwin. Wherefore, pursuant to the law detailed in his memorandum in support of this motion, as well as the facts contained in this motion, the defense requests the court to dismiss all charges against Richard Allen. Beautiful. All right. So I wanted to do this in one part, but we still have 11 pages to go. Let's just do it. All right. So, memorandum of law in support of defendant's second motion to dismiss based upon newly discovered, destroyed, and or missing exculpatory or potentially useful evidence. At issue is a purposeful or negligent failure to preserve and or the destruction of material and exculpatory evidence critical to the defense of Mr. Allen. It also involves the attempted concealment of the identity of a key witness, later identified as Professor Jeffrey Turco, and other exculpatory evidence such as the Todd Click letter and evidence referred to by Click in his letter. This would include new examples of missing evidence detailed in the motion filed simultaneously herein. According to this Indiana code, states that the court may, upon motion of the defendant, dismiss an information upon certain grounds. In this case, the defendant requests the court to dismiss this information pursuant to Indiana Code 3534-14811, blah, 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 which states that a motion to dismiss an information may be granted for any other ground that is a basis for dismissal as a matter of law. Such grounds would include a violation of a defendant's constitutional right to due process, which I think has been happening over and over and over again to poor Richard Allen. Additionally, trial courts have inherent authority to dismiss criminal charges where the prosecution of such charges would violate a defendant's constitutional rights. Section 353414 is merely legislative recognition of this authority. Such grounds would include a violation of the defendant's constitutional right to due process. A motion to dismiss based upon a ground specified in Indiana Code 3534-14811 may be made or renewed at any time before or during trial. Therefore, this matter is properly and timely raised. Excuse me. The Indiana Supreme Court has held that a serious breach of duty occurs when the prosecution willfully or intentionally, when unjustified by a public policy, obstructs the access of the defense to material evidence in its possession. I would say that has been happening repeatedly in this case, as evident in the motion to dismiss, or rather the second motion to dismiss. It is likewise a serious breach when through lack of vigilance, the negligent destruction or withholding of material evidence by law enforcement officers or the prosecutor occurs. In such instances, grounds for reversal may exist. So even if this goes to trial and Richard Allen gets convicted, all of the things brought up before trial here in these motions could be grounds for reversal, this motion to dismiss. meaning, his conviction could be overturned. So, the Indiana Supreme Court has also held that the negligent or intentional destruction of evidence by the police can provide grounds for reversal or dismissal on due process and due course of the law grounds. Prior to any request for discovery by the defendant, the negligent destruction of withholding of material evidence by the police or the prosecution may present grounds for reversal. The Indiana Supreme Court has further held that when the prosecution determines evidence to be non material and further decides not to advise defense counsel of such evidence prior to its destruction, a heavy burden rests upon the prosecution to demonstrate that the destruction of such evidence did not prejudice the defendant. The appropriate test to apply when deciding whether a defendant's due process rights have been violated by the state's failure to preserve evidence depends on whether the evidence in question was potentially useful evidence or materially exculpatory evidence. Blanchard versus State, which I feel like we've read in basically all these motions in, Karen Reid and others where we're trying to get the investigation looked at. All right, so the burden and exculpatory evidence or evidence being withheld. So the burden is on the state to demonstrate that this evidence was not material and its destruction did not prejudice the defendant. So the burden's on the state to prove it wouldn't help the defendant. Potentially useful evidence is defined as evidentiary material of which no more can be said than that it could have been subjected to tests, the results of which might have exonerated the defendant. The state's failure to preserve potentially useful evidence constitutes a due process violation when the defendant can show bad faith. The Seventh Circuit has held that bad faith may be inferred when a party disposes of evidence in violation of its own policies. So it doesn't even have to be willful and not just willful, but like intentionally underhanded. It doesn't have to be that. It could just be bad faith in showing like, hey, we accidentally got rid of this evidence or whatever, and we didn't mean to. We accidentally videotaped over these, and it's our policy not to videotape over interviews. So, we kind of messed up there. And that's what that's saying. So, violation of a record retention regulation creates a presumption that the missing records contained evidence adverse to the violator. So, meaning law enforcement who, or the prosecution, whoever is withholding the evidence. The bad faith presumption arises when the failure to retain records or other evidence actually violates the terms of the applicable policy. However, the Indiana Court of Appeals has noted that in some instances, the destruction or failure to preserve evidence may be so prejudicial to the defendant as to warrant reversal, even in the absence of bad faith by the officer. So you don't even have to prove that it was bad faith, but that the destruction of this was so egregious, basically. Destruction or failure to preserve evidence that would be prejudicial to the defendant also would warrant a reversal. So, material exculpatory evidence, on the other hand, is defined as evidence that possesses an exculpatory value that was apparent before the evidence was destroyed and is of such a nature that the defendant would be unable to obtain comparable evidence by other reasonably available means. The state's good or bad faith in failing to preserve material exculpatory evidence is irrelevant. The Indiana Supreme Court has held that the defendant must establish materiality as a condition precedent to claiming a denial of due process where evidence is negligently lost or withheld by the government, except where the materiality is self-evident or a showing of materiality is prevented by the destruction of the evidence. So I can't show you that it's material evidence because it's destroyed. but it's pretty self-evident that basically everything about Brad Holder has been kept from the defense. So that makes you wonder. An item is material if it appears that it might benefit the preparation of the defendant's case or if it might reasonably affect the outcome of the trial. I'd say one of the first suspects' interviews and notes on those interviews and reports and whatnot would be pretty material. In this matter, given the nature of the evidence that law enforcement either failed to preserve or actually destroyed, the materiality was and is self-evident. Furthermore, as in Lee, the failure to preserve or destruction prevents the defense from establishing the exculpatory nature of the evidence and its materiality. As such, Allen is not required to demonstrate the materiality of the evidence. These are beautifully argued. I don't know the law. I would just know, like, what he's telling me, he's got me convinced with his arguments. Like, if I was the judge and I was reading this and I was just impartial and I'm reading this, I'd be like, you sold me. Obviously, I'd need to hear the other side too, but, I mean, these are, there's a lot of evidence that they are providing in these motions to disqualify, motions to dismiss, motions for sanctions, and yet because we have a biased judge, they just keep getting denied without hearing with no legal analysis as to why. So it's been, I'm sure, very, very frustrating for these guys, and I hope she just recuses herself. Like, why not just recuse herself? I don't understand. To be sure, the unavailable evidence had exculpatory value, which was apparent at the time it should have been preserved and prior to its destruction. Additionally, Allen is unable to obtain comparable evidence by other reasonably available means. Spoliation of evidence is the intentional destruction, mutilation, alteration, or concealment of evidence. If spoliation by a party to a lawsuit is proved, rules of evidence permit the jury to infer that the missing evidence was favorable or unfavorable to the party that lost it or destroyed it or whatever, spoiled it. So even if this court requires a showing of bad faith, it is apparent. Bad faith is defined as being not simply bad judgment or negligence, but rather implies the conscious doing of wrong because of dishonest purpose or moral obliquity. Obliquity is defined as deviation from moral rectitude or sound thinking. That's from Webster's Dictionary, and I love it. I love that they are defining all the words. Like, you cannot, for any reason, misunderstand what I'm trying to say here, because I'm defining what bad faith is. I'm defining the spoliation of evidence. Why is that so hard for me to say? They're defining what material means. They're defining all these words for you so that you can't come back and argue and be like, oh, wait, no, that's not what material means. The United States Supreme Court has recognized that the police have a constitutional duty to preserve such evidence. In Trombetta, the Supreme Court observed that whatever duty the Constitution imposes on the states to preserve evidence, that duty must be limited to evidence that might be expected to play a significant role in the suspect's defense. The court recognized that same duty in Arizona versus Youngblood, confirming that the Constitution imposes at least a limited obligation on the police to preserve evidence that could form the basis for exonerating the defendant. It is beyond debatable that the evidence at issue here would play a significant role in Mr. Allen's defense and would form a basis for exonerating him. Additionally, the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the bad or the good faith of the prosecution. So it doesn't matter if it's in good faith or not. Suppressing things, when the prosecution suppresses evidence favorable to the accused, That's violating due process. Plain and simple. Brady versus Maryland. To prevail on a Brady claim, a defendant must establish one, that the prosecution suppressed evidence. I think we can establish that. And two, that the evidence was favorable to the defense. I think so. And three, that the evidence was material to an issue at trial. Yeah, pretty material. Pretty material to the trial. It is clear that the federal Constitution is not the sole guarantor of the right to due process and other rights. Chief Justice Shepard made this abundantly clear in his Law Review article, Second Wind for the Indiana Bill of Rights, when he stated in conclusion that civil liberties protected only by a U.S. Supreme Court are only as secure as the Warren Court or the Rehnquist Court wishes to make them. The protection of Americans against tyranny requires that state Supreme Courts and state constitutions be strong centers of authority on the rights of the people. I am determined that the Indiana Constitution and the Indiana Supreme Court be strong protectors of those rights. The Chief Justice also stated that Indiana was an early and noteworthy participant in using its Bill of Rights to defend personal liberty, and after citing two numerous early decisions, noted that there were but a few in a fine line of cases in which the Indiana Supreme Court held that the Indiana Bill of Rights afforded Hoosiers rights, which the federal Constitution did not. Chief Justice Shepard also made note of the fact that many provisions of the Indiana Bill of Rights have no counterpart in the United States Constitution and observed that Article 1, Section 12 was one of those provisions. This provision relating to due process is at issue in this instant case. The Due Process Clause of the United States Constitution is found in Section 1 of the 14th Amendment to the Constitution. That section states that, in relevant part, that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. The right to due process conferred under the Constitution of the State of Indiana is found in Article 1, Section 12, and contains significant language not found in the Constitution of the United States. The provision states, all courts shall be open, and every person for injury done to him in his person, property, or reputation shall have remedy by due course of law. So, I need every person should be afforded the due process, their rights. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. While the defense is unaware of any Indiana case law specifically interpreting the emphasized portion of this Constitution provision, the provision itself was traced back to the Magna Carta in State Ex Rel. Board of County Commissioners versus Larimore. The Larimore Court also acknowledged that although the provision was derived from the Magna Carta, it may be a broader guarantee of free, unpurchased, and impartial justice. Three more contemporary decisions dealing with the issue of destruction of evidence are of particular import. First, it is clear from Chief Justice Shepard's concurrence in House v. State that the issue of whether a lack of good faith the lack of good faith on the part of the state was required for a defendant to obtain a remedy for the destruction of potentially exculpatory evidence under the Indiana Constitution had not been decided adversely to the defendant, even after Youngblood. The House decision actually dealt with the discovery of potentially exculpatory evidence and the need for materiality of that evidence. Both Chief Justice Shepard and Justice DeBruler, however, discussed the related issue of destruction or loss of such evidence in his concurrence and dissent. Justice DeBruler stated that while I agree with the result reached by the majority opinion on this discovery issue, I point out that when the accused shows that material evidence was in the hands of the prosecution and lost, the question of whether the accused must then go ahead and show prejudice is open in Indiana. In my judgment, when the item is not available for scrutiny by the trial court, but is known to have been material, the risk of loss should be borne by the prosecution, not the defendant. The police and prosecutors are, after all, highly trained specialists. The police and prosecutors are, after all, highly trained specialists, that's how that was said, in the gathering and retention of evidence and should be expected to carefully retain all material evidence in usable form. Beautiful. Police, prosecutors, you're all supposed to be trained in preserving this evidence. So the fact that it has not been preserved or retained, for that matter, that's on you. That shouldn't be on the defendant because the defendant can't get because it's been destroyed now. So they can't even use it for their case, which it could have totally exculpated him. Chief Justice Shepard, in his concurrence, stated that I agree with Justice DeBruler that this case does not decide what standard Indiana should use for cases in which the prosecution has disposed of arguably material evidence which might exculpate a defendant. This instant case certainly appears to be the type of envisioned by these comments. 2 Indiana decisions have been found in which the issue of due process and the destruction of evidence was raised under both the federal and Indiana constitutions. Although both of these decisions were determined adversely to the defendants based on the facts of the cases, both also stated that negligent or intentional destruction of material evidence by the police or the prosecution may present grounds for reversal. In each case, the defense alleged a violation of due process under both the federal and state constitutions. While both decisions were rendered prior to the United States Supreme Court's decision in Youngblood, the decision in House rendered after the Youngblood decision makes it clear that the principle announced in Hales and Douglas may still be valid under the Indiana Constitution. Additionally, Lee was decided after Youngblood. So just all these other cases that they're providing here. If the language of Article 1, Section 12 of the Indiana Constitution, justice shall be administered freely and without purchase, completely and without denial, speedily and without delay, is to have any meaning at all, it certainly seems to support a more stringent enforcement of due process rights than required under the federal Constitution. Given the facts of the instant case, the penalty involved, and the long history of concern about preservation of evidence in Indiana case law, as well as evidence of attempts of law enforcement and the state of Indiana attempting to conceal other material and exculpatory evidence, Mr. Allen should not be deprived of a remedy for the egregious loss of evidence occasioned by the actions of law enforcement and or the prosecution in his case, especially in light of the ease with which the evidence could have been preserved. Conclusion: the only remedy that serves the interest of justice and guarantees Mr. Allen's constitutional rights is dismissal. Thank you, Baldwin and Rosie. That was also beautifully written. Thank you for fighting zealously for Richard Allen and being that advocate that he needs in the court of law, especially when there is a potentially biased judge. I mean, she's not even potentially, I'm just going to say Judge Galt is biased. And for that reason, I absolutely am grateful that there are people in this world like Baldwin and Rosie who are fighting so hard for the innocent people that are sitting in prison and being totally railroaded by the government. And this happens more than you want to believe. It's not impossible. It happens especially in tiny towns where power of the power of law enforcement seems to take shape, where it starts to become corrupt, and even law enforcement and prosecutors working together adds to some of that corruption when you realize that they're all against your client, all working against you: law enforcement, the judge, the biased judge that won't rule on anything with a hearing. It's just crazy. This case is insane. Let me know what you guys think in the comments below. I find it very interesting. I wonder what's going to happen regarding the disqualification and motion to dismiss, because I'm hoping that they get a new judge. Just right off the bat, recuse yourself, Judge Gull. Let's get a new judge. If they have to, I think they're going to go to the Supreme Court again. I think they have more than enough. I think this is more than enough to get Judge Gull, not the motion to dismiss. Maybe for Nick McClelland, it's more than enough to get him out of his role. But I think the motion to disqualify that we went through in parts 1 and 2, I think that they have more than enough to get rid of Judge Gull, and to not only get rid of her off this case, but potentially, I think there should be some ramifications as to what she's done. There should be some accountability on her end for she's delayed this trial multiple times now for Richard Allen. She's forced his hand multiple times. She's forced him to give up his speedy trial rights twice now. So it's very, very unfortunate. And I think that, unfortunately, the big unfortunate part is that Judge Gull, judges, prosecutors, they have like this special immunity, which I think needs to go bye-bye. We need to get rid of that, and we need to make people accountable of their actions. You can't just go around accusing people of homicides and throwing them in jail and taking away their possessions and taking away their rights as a citizen of this country just because you have some inkling, or you have an election coming up and you think it's going to look good for you if you get someone behind bars for this case, which seems to be partly what happened here. We don't know for sure, but it does, speculation may, and reading the evidence kind of makes you think that. So I don't know. I'm hoping just that Judge Gull just says, yeah, fine, I'm done with this headache. I recuse myself, but I know she's not going to. She's going to have to write a report now as to why she denies it, and then they're going to have to go to the Supreme Court, I bet, after that, or do some kind of appeal, some kind of something, if there's that kind of remedy in Indiana. I don't know, but hopefully Judge Gull goes bye-bye. And we need accountability. We need to start keeping our judges, prosecutors, law enforcement accountable, especially for situations like this. We need to prevent situations like this. So hopefully we learn and we do better. That's all we can ask for. So take that thought with you for the rest of the day, and I hope to see you guys in the next video. Thank you so much for watching. Take care and have a good night. Bye, guys.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.